Adjustment of status. Can I adjust my status while in removal proceedings? Can I adjust my status while my asylum case is pending? Can I adjust my status when I overstay my visa? In this video, I'll talk about adjustment of status. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy those type of content, come on, go ahead and give me likes, share, and don't forget to comment below. Let's get right into it. Adjustment of status, assuming that you have a basis for it, okay? Because a lot of people get confused and they keep calling and asking, oh, I want to adjust my status. And then when we ask them, do you have a basis upon which you want to adjust your status? And they don't have anything really. In order to be able to adjust the status, you either are adjusting a status because you got married, or let's just say under family type of adjustment, or under employment, any type of employment, whether religious, whether self-employment, whether another employer try to sponsor you, or just whether self-sponsor type of adjustment of status, okay? But you have to have a basis upon which to adjust the status. Assuming that we have covered the basis and you're ready to adjust the status, can you in fact adjust a status? Number one, applicant must have been inspected and admitted or paroled into the US in order for them to be eligible to adjust the status. Meaning what? You get to the US at the port of entry, you get your admission on your passport, or some people come by way of borders, but you get parole. So basically you get permission to enter into the US if you don't have a valid visa. So you must have been inspected, okay? But if the person is not inspected, there is an exception to it, which means that you have to be falling under the grandfather clause, which simply says that petition must have been filed on April 1st, 2001 as a priority date, and then you pay a $1,000 penalty fees in order for you to waive that inspection requirement, okay? And then the second point is that basically the second requirement is that the applicant must be eligible for an immigrant visa and admissible for permanent residence, and a visa must be immediately available. That's why we have category of people who have visa immediately available, especially immediate relative, spouses, children, and parents. Their visa are immediately available, so they don't have to wait for a visa to become available. Once they get the approval of the form I-130, they can go ahead and adjust a status. But wait a minute, must also be admissible. Remember, we have talked about grounds of inadmissibility. If you fall into those categories, whether it's unlawful presence, whether it's violation of visa, especially for students, whether it's crimes, whether it's something else. So basically those grounds that we have talked about previously can render a person inadmissible and therefore not able to adjust status. So all the conditions have to be met. And we have certain people too who can adjust status concurrently. For example, via petitioner. Once you file your form I-130, especially spouses, children and parents, because the visa is immediately available if you get approved. That's why you can file the form I-360 with the form I-45 together, because the visa in that category is already available, okay? When the person gets an approval. So we cover that. And then let's say you are not, you were found inadmissible, then you are entitled to a waiver. But remember, waiver Waivers are discretionary measures. Only the Attorney General can give the waiver provided that you meet statutory requirements first, and then you apply and you have a qualifying relative, children, spouse, or a parent, and you can prove extreme hardship in order to qualify for a waiver and apply really for adjustment of status. Okay, now the question that we're going to answer is the question that we're going to answer is the question that I asked before at the beginning of this video. Remember, I said, can I adjust the status while in removal proceedings? Can I adjust my status while my asylum case is pending? Can I adjust my status when I overstay my visa? Let's answer those three questions. The first one, can I adjust my status while in removal proceedings? In removal proceedings, adjustment of status can be a form of relief. So, for example, if you are adjusting a status based on marriage, you got into the US and then you find yourself removable. That's why now the person is in removal proceedings, and after the fact or while the case is pending in removal proceedings, the person got married. So now the person wants to adjust the status. Is it possible? Of course, it's possible. However, you must be able, that person must be able to prove by clear and convincing evidence that the marriage has been entered into good faith. Remember, we go back to our previous videos on marriage entered in good faith. Clearly, you have to prove that the marriage is for love, not just to evade immigration laws. Okay, and that's the standard really in removal proceedings become even higher, because now everything is at stake, because you were first of all found removable, and now you want to just status. Basically, it just looks like you just want to stay. The person wants to stay because they find themselves in a situation that they are getting married. But marriage, remember, it's a fundamental right. Anybody can get married at any time, provided that the marriage is valid. So clear and convincing evidence. That's how you can adjust a status into removal proceedings. Let's say you have another basis to adjust status in removal proceedings. For example, if you want to adjust status in removal proceedings based on a child petitioning for a parent. Let's say you came to the US, now your children are grown, past 21 years old, they work, financially stable, they can sponsor you into a green card, but unfortunately, the person finds themselves in removal proceedings. The question now becomes, can I adjust my status under my child? Of course, you can adjust your status under your child, but this is going to be a very challenging case, because this is not a case of marriage where you can just prove by clear and convincing evidence that the marriage is in good faith. Here, now the question becomes, you did not maintain a non-immigrant status. Remember that asylum, a lot of people find themselves in removal proceedings basically based on asylum. They file for asylum. That's the majority. Sometimes they file for asylums, and then asylums at the immigration office didn't work well. The case gets transferred or referred to an immigration judge. At that point, the person becomes removable. But now the question is, again, can I adjust my status? The standard here is different when the person is adjusting under their children. They have to prove that it wasn't their fault, not fault of their own, that they couldn't maintain a non-immigrant status, a valid non-immigrant status, and then, or they have to prove that it was for technical reason that they couldn't they couldn't actually maintain a non-immigrant lawful status. So this is really technical. This is really a matter of argument. We have a case law there, but this is really a matter of showing that the facts really are in correlation with the the case law that we'll use to argue so that the person can adjust the status while in removal proceedings. Okay. Another example will be, can I adjust status basically based on employment when I am in removal proceedings? The standard again becomes, have to show why you couldn't maintain a non-immigrant status valid, basically unlawful presence, and then it wasn't your fault, and maybe technical reason that's why you couldn't. But remember, certain employment have a what they call an exception and waivers, and they can really in fact adjust their status even though they did not maintain their non-immigrant status valid in the US. So that if you want to know more, or you can either call my office 202-751-2180 or email me directly, email on display. And please be advised again that consultation fees apply. We will not talk to you until you sign the consultation agreement and you agree to pay the necessary fees. Okay, let's move along. And now the second question is, can I adjust my status while my asylum case is pending? Immediate relatives really do not have a challenge when it comes to adjustment of status. Still, if it's to marriage, you still have to prove that the marriage is entering good faith. We've talked about good faith marriage before. Please refer back to my previous videos. If it's to employment, again, the standard is really you have to show why you couldn't maintain a non-immigrant status, a valid one. And waiver could be required as well to waive that unlawful presence. Remember that when somebody is filing for asylum, they don't have a immigrant status. They don't have a valid non-immigrant status. They don't have an immigrant one because the asylum hasn't been approved yet. Then they don't have a valid non-immigrant status because the only thing they have is the permission to stay on the American soil until the case get adjudicated, until the case get decided. Okay, so that's why a lot of people have reached out to me asking as to why they couldn't adjust their status to their parents with their immigration when their visa became available, really with that petition, and then they filed for the form I-485 while their asylum case was pending and they couldn't adjust the status. It's really because that the asylum pending is not a status, it's just a permission to stay in America, on the American soil until your case gets decided. So basically, the language they use right there is like you did not maintain a non-immigrant status, so you were not into a good status. So basically, undocumented. Okay, just for lack of better words. So. And then now we have to prove using that case law that it wasn't your fault that you couldn't maintain that non-immigrant status, or for technical reasons really you couldn't maintain. And technical reasons come into play. Let's say that you had a visitor visa and really you file your extension and still haven't gotten a response yet. And in the meantime, your visa becomes available and you file for your petition to get a green card, and the green card gets denied. There's technical reason in between because at the same time they haven't responded to you for the basically for your extension of that B1 visa, and at the same time they're denying your I-485 form. So then you have to tell them it's your technical issue, not mine, because I extended the visa in order to remain lawfully present in the US, but you haven't responded to me, and now my application got approved, I-130, but you still are denying my case. So in between, what should I do? So there is an argument that needs to be made, okay? Solid, of course, in order to win and get your green card. So overstay of visa, the same thing. Really unlawful present. If you unlawful present in the US, waiver is required. if you try to extend the visa in the meantime but hasn't got the response yet, we can make an argument, and really a solid one. Remember, arguments are not a guarantee, but we try the best that we can in order for you to get that Queen Court, really. And if the argument fell us, then we go with the waiver. But really, it's a matter of, did you maintain a non-immigrant status at the time of adjustment of status? So basically, lawfully present in the US. And another thing I wanted to add is that for immediate relative, really, it gets, don't complicate the story. If it's an immediate relative and you find yourself unlawfully present at the time of adjustment of status, just file with a waiver because you have a qualifying relative. And if there is an argument to be made, let's make that argument, because you will get a denial and get so stressed out because you don't understand why they couldn't adjust your status. But the reason being is that the way they work with Green Court is different. They have to go point by point. They go by the book, really lawfully present or not, or that's just one, not or, and admitted and inspected. So basically they have to just go by the book. If one doesn't ring the bell, they just cross no, and then the denial letter is there. So that's it for today. And there are certain people really that cannot adjust status at all. They're really bored to adjust status unless they go outside of the US and apply for a different type of visa in order for them to adjust status. So those people are persons that were admitted as crew members, okay? Those admitted in transit without a visa, other than immediate relative non-citizen under the visa waiver program. Those people can actually, in fact, apply for a waiver in order for them to adjust status. Non-citizen admitted as immigrant, okay? And then employment-based applicant not in lawful non-immigrant status. So basically you have to have a lawful immigrant status, unless you, when you apply, you were into a lawful immigrant status, and then your application stayed there with them for longer, like 180 days or more, and at the time you lost your lawful presence, because basically, let's say you got with a B1 visa here, and then within that 6 month time frame you apply for employment based and adjustment of status based on employment, and then the application is taking longer, and in the meantime you lose your status, your non-immigrant status. At that point you can use that exception, okay? And then we have those who have taken employment while being unauthorized aliens, or have otherwise violated the terms of the non-immigrant visa. So in violation, those are just grounds of inadmissibility. They're just repeating them in different words. We already talked about those grounds of inadmissibility. So that's it for adjustment of status. This is the main topic, because at the end, if you really want to stay in the US, basically as a green card holder, at some point the person must adjust their status, and then they have to meet those requirements. That's why the subject is so important for people interested in adjusting their status, okay? Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. This was US immigration, and this was Sunday evening, okay? We're doing it, remember, it's Sunday, but we still have to work, okay? And we still have to do what is necessary. Whatever is necessary needs to be done. Until next time, bye-bye.